Welcome back, sir. Let us start with the next chapter, sir. Chapter number 3, considerations, previous exam questions, MTPs, RTPs from the third chapter, sir. So, first question number 1. This question was asked in May 2008 for the 5 marks, sir. So, this question was asked so many times, sir, not only once. State the exceptions to the rule. An agreement without consideration is void. Agreement without consideration is void. So, we are having a general rule, sir. No consideration is equal to no contract. No consideration is equal to no contract. Why? Because as per section 10 of the Indian Contract Act, consideration is one of the essential element. If section 10 is not satisfied, no, that is void ab initio agreement. So if there is no consideration, no contract, it will become void ab initio agreement. It will become void ab initio agreement because consideration is mandatory, beta. In Latin, it is said to be nudum pactum, beta. In Latin, it is said to be nudum pactum. Nudum pactum means no consideration, no contract. The effect will be void ab initio. But Act only saying that in some exceptional cases, even without consideration, there is a valid contract is there. The first one is the agreement made on account of natural love and affection. We have discussed in the face-to-face class also. So agreement without consideration is valid if the agreement is in writing. If the agreement is in writing, if the agreement is registered, if the agreement is registered, everyone write, sir. If the agreement is registered, if the parties to contract are standing in the near relationship, and there must exist natural love and affection. Natural love and affection. If these 4 conditions are satisfied, no matter, even without consideration, there is a valid contract is there. For example, my father said to me, Srinath, if you clear CA foundation in first attempt, I will give you 1 lakh rupees. I will give you a bike. I will give you bike. So my father gave the agreement in writing. My father said, I will give you bike. I will give you bike if you clear CA foundation in first attempt. So the agreement is in writing. The agreement is registered with the registry office, and me and my father are in a near relationship only. Close relationship is no, beta, father and son. And my father said to me, out of love and affection, beta, this agreement is enforceable. My father is not giving me any bike. After clearing CA foundation, I can file a case with my father to recover my bike because all the conditions are satisfying here. So agreement is in writing, agreement is registered, the parties should understand the near relationship, and also there exists natural love and affection. So this agreement is enforceable even without consideration. See, any written registered agreement made on account of natural love and affection between the parties standing in the near relationship will be enforceable even without a consideration. Even without a consideration. Second one, second exception, from compensation for the past voluntary activity. Past voluntary activity. Voluntary means without expecting anything. Without expecting anything. For example, beta, my friend saved my bike. My friend saved my bike without, actually my bike met with accident or the fire accident. So one of my friend saved my bike from the fire accident. I promised him to give 1 lakh rupees. So this contract, this is a contract, and it is enforceable even without valid consideration because it is a promise made to compensate the past which activity, voluntary activity. He was helping me in the past. That too, he was done that activity voluntarily. So I am promised to compensate that act. This agreement is, the contract is enforceable, sir. A promise to compensate wholly or part a person who was already voluntarily done something is enforceable. Yes sir, no sir. We have discussed one case law also. So 2 persons are there. Neighbor building is attached with fire accident. So this is enforceable, sir. Next, promise to pay time barred debt. Time barred debt means expired debt. As per Limitation Act, the validity of the debt is 3 years. After 3 years, the debt will become zero. Void ab initio. It will become void contract. Sorry, it will become void contract. But I am promising to make that time barred debt. It will be enforceable. But it must be in writing. It must be signed by the person, signed by the debtor, or his authorized agent, It will be enforceable even without consideration. है ना बेटा? For example, I give the money to Rohit on 1 lakh rupees. I can recover this loan within how many years beta? 3 years. That is 1/1/24. After 1/1/24 it will become void. It will become void contract. But Rohit promised me to can I recover the loan from the Rohit beta now? No, because all 3 years are expired. On 1/1/26 Rohit promised to pay me time barred debt. It will be enforceable even without any other consideration. है ना बेटा? So this example also we have seen in the regular classes. So next one, yeah. So agency, which agency beta? Gratuitous agency. Write the head here. Write the word gratuitous. Gratuitous agency. Gratuitous means without expecting anything, but without expecting anything. So gratuitous agency does not require any consideration because the heading itself says that gratuitous agency, as per section 1/5 of the Indian Contract Act, no consideration is necessary to create the agency. That is gratuitous agency. And completed gift beta. Gift will not require any consideration, but gift is given for free of cost. We will not sell the gift, no. So in case of completed gift, the rule no consideration, no contract does not apply. Explanation 1 to section 25 states that nothing in this section shall affect the validity as between the donor and the donee. Donor is the person who is giving the gift of any gift actually made. Thus, gift does not require any consideration. Next one, gratuitous bailment. Which bailments are? Gratuitous bailment. So this thing also we have discussed in the face-to-face classes. I mean regular classes. Gratuitous bailment does not require any consideration. And charity. Charity is similar to gift, but gift is given to specific person. Charity is given for the society in general. Society in general, that is said to be charity beta. Distributing the food to orphans, that is a charity. Giving gift to my wife, it is a completed gift. So a promise, if a promise undertakes the liability on the promise of any person to contribute to charity, consideration the contract will be valid even without a consideration. Second question beta. To form the valid contract, consideration must be adequate. Statement must be true or false, sir? True or false? To form a valid contract, consideration must be adequate. Statement must be true or false, sir? False. Statement is false. Adequate means sufficient beta. Adequate means sufficient. Adequate means sufficient. Consideration need not be sufficient. It can be grossly inadequate also. For example beta, statement is false beta. SG, myself SG, I am selling the car to Rohit. I am selling my Jaguar car. I am selling my Benz car to Rohit for 10 rupees. Contract is valid and invalid. I am selling this car, Benz car to Rohit for the 10 rupees beta. How much beta? 10 rupees. The contract is perfectly valid. Contract is perfectly valid because consideration need not be adequate. Consideration need not be adequate. Consideration can be grossly inadequate also. वो कार मेरा कार है, वो मेरा गाड़ी है, वो मेरा मर्जी है. Who the hell are to question me? I am having this mobile. Can I sell this mobile for 10 rupees? Yeah. How can you question me for selling the mobile for 10 rupees? वो मेरा मर्जी है. Is iPhone worth of 1 lakh rupees selling for 10 rupees? Out of my wish and my will. So consideration need not be adequate. It can be grossly inadequate also, but consent must be free consent. Out of my own wish, I'm selling my car to Rohit for free 10 rupees. I can give my car to Rohit for free of cost also. Who the hell are to question me? Perfectly valid. So to form a valid contract, consideration need not be adequate. Need not be. It can be grossly inadequate also. It can be grossly inadequate also. See. The law provides that a contract should be supported by some consideration. Which consideration beta? Some consideration. As long as consideration exists, courts are not concerned about the adequacy, provided it has some value. Which value beta? Some value. If you observe in the market, one vendor will sell the apple for 30 rupees, another vendor will sell the same apple for 20 rupees, another vendor will sell the same apple for 10 rupees also. Can you file a case on him for selling the apple for 10 rupees? No. Consideration need not be adequate. It can be grossly inadequate also. The statement is false statements. Remember? So the adequacy of the consideration is for the parties to consider at the time of making the agreement, not for the court when it is sought to enforce. The court will not inquire how much money you are giving. Money is there or not. No money, no consideration, no contract. Consideration can be more, it can be less also. For example, in our teaching profession also, some people will charge 2000 rupees per hour. Some people will charge 1500 rupees per hour. Some people will charge 1000 rupees per hour. Some people will charge only 100 rupees per hour. Oh, उसका मर्जी है ना बेटा? Can I file a case on him for charging 100 rupees only per hour? No, sir. है ना बेटा? Consideration must be there. It need not be adequate. It can be grossly inadequate also. But consideration must be free consent, sir. Remember that one. Consideration must however be something to which the law is attaching value. That means it must have some value in the eyes of law. 10 rupees is having a value, no beta? Though it need not be equivalent value. It need not be equivalent value. It can be grossly inadequate also. As per section 2, as per explanation 2 to section 25 of the Indian Contract Act, an agreement to which consent of the parties is freely given. This one is important beta. Consent must be free consent. Consent must be free consent. Consideration need not be adequate. So which consent of the promissory is given, freely given, is not void. That means contract is perfectly valid if the consent is free. So merely because consideration is inadequate, but inadequacy of the consideration may be taken into account by the court in determining the question whether consent of the given promissory is free or not. If the consent is free consent, consideration need not be adequate. It can be grossly inadequate also. Simple, one line only. If the consent is free, then consideration need not be adequate. Need not be adequate. That is, it can be grossly inadequate also. Grossly means lot of difference can be there. You can draw this diagram also, beta. Is G selling a bike? Is G selling the this which car, beta? Jaguar car or the Audi car or the Benz car to Rohit for how much, beta? 10 rupees. Still perfectly valid. What I'm taking 10 rupees, what I'm giving bench car, perfectly valid. See, next question. This question came for the how many marks? Beta 4 marks. 2019. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines is there, beta. Question itself is 10 lines, but you're having only 4 marks. For each mark, you're having nearly 1 or 2 seconds in the exam. That means in 400 seconds you have to understand this question and you have to answer. Moreover, this question is important, sir. Similar kind of question came 4 to 5 times in the exam. Keep the maximum number of stars. So Mr. Sohanlal sold 10 acres of his agricultural land to Mohanlal. Mr. Sohanlal sold 10 acres of his agricultural land to Mohanlal on 25th September 2018 for 25 lakhs. The property papers mentioned a condition among the other details that whosoever purchases the land is free to use the 9 acres as per the choice, but remaining 1 acre has to be allowed to be used by Mr. Chotelal, the son of the seller, for carrying out farming or any activity in his choice. On 12th October 2018, Mr. Sohanlal died, leaving behind his son and life. On 15th October 2018, the purchaser started construction of auditorium on the whole 10 acres of the land and denied any land to his son. Now Mr. Chotelal wants to file a case against the purchaser and get a suitable redressal. Discuss the above in the light of the provisions of the Indian Contract Act 1872. Decide upon Mr. Chotelal's plan of action. क्या बात कर रहा, कुछ समझ में नहीं आ रहा बेटा? So let us try to convert this Sanskrit into English. है ना? कितना बड़ा है क्वेश्चन बेटा? Understand the question itself is मुश्किल. Let us see what was happened in this question. Important beta. Sohanlal sold 10 acres of agricultural land to Mohanlal. So there is a person called Sohanlal beta. Who beta? Sohanlal. He is a seller. He is the seller. He is giving 10 acres of the land to whom, beta? To whom? Huh? Mohanlal. He is the buyer. Mohanlal is the buyer. Selling the how much of land, beta? 10 acres of the land. On 25th September 2018 for 25 lakhs. So on 25th September 2018 for how many lakhs, beta? 25 lakhs. Till now clear, happy. नेक्स्ट क्या है बेटा, इधर इधर तक हो गया ना. तो till here no problem. The property papers mentioned a condition among the other details that whosoever purchased the land is free to use 9 acres of his choice, but remaining 1 acre has to be allowed to be used by Chotelal, the son of the seller, for carrying out the farming or any other activity. So he said to buyer, out of 10 acres you can use only 9 acres. That means he's selling on 9 acres better. In fact, 1 acre should be given to Chotelal. He was the son of the seller, who is son of Chotelal. Son of the Sohanlal, sorry. Chotelal is the son of the Sohanlal. Who is son of Sohanlal. Happy. So there is a condition, beta. So Mohanlal said, my dear Chotelal, I will give you 1 acre of the land to you. This was the agreement between the Mohanlal and Chotelal. If you are seeing this image, are you getting anything, beta? This kind of image we have seen in the regular classes. Which case la is coming into your mind? Chinnaya versus Ramaya. If you observe, good father, good mother, bad daughter. Father said to daughter, one agreement is there. Daughter said to mother, one more agreement is there. है ना बेटा? So till now happy बेटा. किधर तक हो गया? इधर तक हो गया. 1 acre has to be allowed to be used by Chotelal, the son of the affair choice. इधर तक हो गया. देन बाद में क्या हो गया? On 12th October 2018, Sohanlal died, leaving behind his son and life. On 15th October 2018, the purchaser started construction of the auditorium in whole 10 acres. So after death, कब मर गए उन्हें? 12th October Sohanlal died. वो मर गया. Since he's deceased, no beta, he is not supposed to smile, no. So when he is dead, beta, in this example, 12th October 18, वो मर गया. Subsequently, this guy is there, beta, Mohanlal, trying to use the 10 acres of the land. है ना बेटा? 10 acres of the land for construction of a auditorium for whole of the land. Denied any land to his son. Now Mr. Chotelal want to file a case against the purchaser to get the suitable redressal. Discuss. So now Chotelal want to file a case on the Mohanlal to get 1 acre of the land. Mohanlal is saying that, if I give you 1 acre of land, what will you give me in return? Nothing. No consideration, no contract. But Chotelal said, you are giving me 1 acre of the land. I am not giving you anything. Something came from you. Something came to you from my father. Consideration need not come from the party to contract. It can move from the stranger also. So who will win the case, beta? Chotelal will win the case. His contention is perfectly valid. If you observe this case la, exactly similar to Chinnaya versus Ramaya case la. Exactly versus similar to Chinnaya and Ramaya case la. है ना बेटा? Yeah. So let us see the answer also, beta funds. Provision of the law. Consideration. Liquos everyone, if you're having a physical material, consideration need not move from party to contract. Need not move from party to contract. This is a heading beta. Step number 1 heading. So problem as asked in the question is based on the provisions of Indian Contract Act section 1872 as contained in section 2D and on the privity of the consideration. Privity means private party. Privity means private party. So that means consideration needed from move from the parties to contract. Consideration is one of the essential elements to make the contract valid, and it can flow from this one is important, beta. This point is important, beta. Consideration can flow from the promisee or any other person. It can move from the promisee or any other person. It can move from the third party also. Consideration can move from the whom, beta? Third party also. In view of the clear language used in the definition of consideration section 2D, it is not necessary that consideration should be furnished by promisee only. Consideration need not come from promisee only. Consideration can come from the third party also. For example, beta, here I'm teaching Rohit. What Rohit is giving me? Nothing. Something came from his father. If you observe here, SG is giving the knowledge to whom, beta? Rohit. But Rohit is giving to me nothing. Something came to me from his father. Consideration can move from the third party also. Here, seller, buyer, Chotelal, Mohanlal, and father. Yes, sir. No, sir. So a promise is enforceable if there is some consideration, even it needn't be adequate, beta. And for it, and it is quite immaterial whether it moves from the promisee or any other person. I am giving you knowledge. What are you giving me? You are not giving me anything. Something came from your father, beta. The leading authority in the decision, Chinnaya versus Ramaya, held that consideration can legitimately move from the third party, and it is an accepted principle of the law. So I have explained the Chinnaya versus case law also here. Chinnaya versus Ramaya full case law. Explained everything here. Next, facts of the present case I have explained in the given problem. Mr. Sohanlal was entered into contract with the Mohanlal, but Chotelal has not given any consideration. Yes, Chotelal is not giving anything, beta. Something is coming from the Sohanlal to Mohanlal. Here, Sohanlal is there, Mohanlal is there, and Chotelal is there. Mohanlal said, okay, I'll give 1 acre of land. What are you giving me in return? Nothing. So, but Chotelal said, you are giving me 1 acre of land. I am not giving anything. Something came to you from my father. Beta. So, Sohanlal to Mohanlal on behalf of the Chotelal, and such consideration from third party is sufficient. So, for this Mohanlal, something is came from whom, beta? Sohanlal, father. Sufficient to enforce the promise of Mr. Mohanlal to allow Chotelal to use the 1 acre of the land. So, further, the deed of the sale and promise made by Mohanlal to Chotelal to allow the use of 1 acre of the land were executed simultaneously, and therefore they should be regarded as one transaction, and there was a sufficient consideration for it. Moreover, it is provided in the law that in case of covenant means conditions, beta. Covenants running with the land, where person purchases the land with a notice that the owner of the land is bound by certain duties affecting the land, the covenant affecting the land may be enforced by the successors of the seller. Covenant means condition. What is the condition, beta? Sohanlal said, my dear Mohan, I will give you land, but one condition, you have to give 1 acre to my son. Beta? So that condition is applicable to buyer, no, beta, Mohan. Decision. In this case, In such a case, the third party to a contract can file the suit. That is who's third party here? Chotelal. Chotelal to the contract can file the suit, although it was not moved consideration. Chotelal is not giving anything to Mohanlal. Something came to Mohanlal from the father. Hence, Chotelal is entitled to file a petition against the Mohanlal for execution of the contract. For execution of the what beta? Contracts. So, fourth question. This question was asked for 7 marks beta. What is consideration? What are the legal rules regarding the consideration under Indian Contract Act? He's asking what definition of the consideration and the features of the consideration. If you read definition, he will give you 3 marks. If you read the legal rules, he will give you 4 marks beta. Clear na? Remember, like this they will allocate in the exam. First, definition of the consideration beta, you have to read the definition as it is without changing comma full stop. So consideration is defined under section 2D. When at the desire of the promiser, promisee or any other person, here any other person is a stranger, promisee or any other person has done or abstained from doing, past tense. A tense, past tense. Does or abstains from doing, present tense. Promises to do or abstain from doing something, future tense. That means consideration can be past, present, future. To such an activity or abstinence. Activity means positive. Abstinence means negative. A promise is called a consideration for the promise. So what is the summary? Here, consideration may move from the promisee or third party. It can be present, past, future. Consideration can be positive. Consideration can be negative. So, if you read this definition beta, they will give you how many marks beta? 3 marks. Let us see the essentials of a valid consideration one by one beta. All these essentials we have discussed in the regular class already, but this only the main intention of this classes is you have to understand the importance of the question, which question is being asked in the exam. The main purpose of this classes is not to explain the concept. The main purpose of this class is to explain the questions. These are the only question papers classes beta. So legal rules regarding the consideration. Consideration must move at the desire of the promiser. See in the definition also is there, no? When at the desire of the promiser is there, no? So we have explained one example also for this also in the regular classes. Consideration must be offered by the promisee or third party at the desire of the promiser. This implies a written element of the consideration. So I gave that example. Chintu lost somewhere where their parents are worrying. So you are searching for the Chintu at my request, at the daddy request. You are doing this activity voluntarily also. I gave this kind of the box also. You are doing this voluntarily, not eligible to get the consideration. You are doing this at the request of the third party, not eligible to get the consideration. You are doing this at the request of the Chintu father. You are eligible to get the consideration. Remember, sir? Next, consideration may move from the promisee or any other person. See here definition it is there. Promisee or any other person. It may move from the promisee or any other person. Chinnaya versus Ramaya. In India, consideration may be forced from promisee or any other person. I am teaching you. I promised to Rohit. Rohit, I will teach you law. I am the promise. Rohit is a promise. Rohit is not giving me anything. Something came from Rohit's father. The promisee or another person who is not a party to contract. In other words, there can be a stranger to consideration, but not a stranger to contract. Stranger to consideration, but not a stranger to contract. Even the statement is important from exam point of view. This statement also asked 3-4 times in the exam beta. This statement is important. Consideration can be executed or the executory. Executory means khatam pura ho gaya. De diya, pen de diya, unne paise bhi de diya. Executory means future. Consideration which consists of a consideration which consists in the performance of an act said to be executed. When it contains the promise, it is said to be executory. The promise by one party may be the consideration of an act by some other party, vice versa. What he is saying, but consideration can be already completed. It can be, we can do in the future also, but it can be past or the future. The same thing here also. Third and fourth similar. Consideration can be past, present and future. It is general principle that consideration is given and accepted in exchange of the promise. Consideration if past may be the motive but cannot be real consideration of subsequent promise. But in the event of services being rendered in the past at the request of at the desire of the promiser, subsequent promise is regarded as an admission that past consideration was not gratuitous. What he is saying, but already I gave a service last week. I was teaching the last week. You are giving the money this week. Beta. So for you, consideration is moved past. For me, it has to come. That is a future. Otherwise, second example, I am giving you pencil. You are giving me 10 rupees. Present. Consideration can be past. It can be present. It can be future also. And this statement was asked in the exam. Beta. Second question or something. Consideration need not be adequate. Need not be adequate. Consideration need not be of any particular value. It need not be approximate or equal value which the promiser for which it has been exchanged. It may be something which law would regard having some value. Consideration must have some value. How much value, beta? Some value. It need not be adequate value. Which value, beta? It need not be adequate value. Clearness until now. Yeah, the next feature of the value consideration, essentials of a consideration law. The next feature is performance of what one is legally bound to perform. Hai. That means in our running notes we give different examples, but explanation will remain same. That is, consideration must be something more than the another name for this heading. Consideration must be something more than the promiser's existing obligation. Promiser's existing obligation. It must be something extra. It must be something extra. So performance of what one is bound to perform. But that means I'm teaching law, I'm agreeing to take 10,000 rupees. Can I ask extra for same law, beta? No. Along with law, I'm teaching auditing also, I can ask extra. Hai. So the performance of an act by a person who is legally bound to perform. Already I'm supposed to teach law for 10,000 rupees. Hai. Legally bound to perform. The same cannot be consideration for the contract. Hence, the promise to pay money to witness is void, for it is without consideration. Hence, such contract is void for want of consideration. But where a person promises to do more that he is legally bound to do, such a promise, provided it is not upward public policy, is good consideration. It should not be vague and uncertain. So if you want, if you're unable to remember this whole para, you can write like this, beta. You can write like this if you're unable to remember everything. This is given by IC, but actually, so if you want to make it some clarification on this this wording, look, beta. Consideration must be already we have written, beta. Consideration must be something more than the promises existing obligation. We have seen one case, lawyer case, we have seen in the regular classes. Lawyer is there, you know. This one is sufficient, but what I have dictated above, that is sufficient instead of this 4 lines. Next, consideration must be real but not illusionary. Illusion means imaginary. Illusion means imaginary. That means it must be something possible. So I said, I will give you 1 lakh rupees if you bring the stars, if you bring the moon, if you bring the sky. Which it is valid, sir? Invalid, because it is illusion. It is imaginary. I said I will give you 1 lakh rupees if you can able to swim the Indian Ocean. Is it possible to swim the Indian Ocean, beta? Impossible. Is that river? No. Ocean. Hai. For steamer it will take 1 to 3 months, 1 to 2 months to reach the other place. So how can we swim the Indian Ocean in 1 week? It is impossible. If it is not possible to perform, it will not become valid contract. Consideration must be real and not illusionary. Consideration must be real, must not illusionary. It must be something to which the law attaches some value. It is the legally and physically. If it is legally, physically impossible, it is not considered as valid consideration. Simply, if you can write like this: consideration must be something which is possible to perform. Consideration must be something which is possible to perform. Right here, sir. Right here. Consideration must be something which is possible to perform. If it is impossible to perform, it is not a valid consideration. It must be something which is possible to perform. If it is impossible to perform, it is not a valid consideration. Next, consideration must not be unlawful, must not be immoral, must not be opposed to public policy. only presence of the consideration is not sufficient. It must be lawful. It must be lawful. Anything which is immoral or opposed to public policy cannot be valued as a valid consideration. So it's very easy sentence only, beta. So consideration should not be unlawful, illegal should not be opposite policy. Hey, beta. I said 1 lakh. I said Rohit, if you give me 1 lakh rupees, I will kill Chinto. I will kill Chinto. I am killing Chinto. Rohit is not giving me 1 lakh rupees. Can I file a case on Rohit, beta? Answer is no, sir. Hey, na? So if read these essentials and also the definition, you will get the 7 marks, beta. For definition 3 marks. Definition we should do it as it is. And essentials, so write the every heading. Even you can explain with 1-2 lines also, that is sufficient. Next beta, 5th to 6th to 7th, same question. 7th question is asked in 2009, 6th question 2007 and 2018. Same question which we have discussed as the 4th question beta. Chinnaya versus Ramaya. See, what we have 2019. Fourth question is 2019. That means question was asked 4 times till now. 2019, 2018, 19, 18 and 2007 and 2009. Hey, beta. So see how much important that case la Chinnaya versus Ramaya. So what was happened in this case? Let us try to understand the 5th question, beta. Next question number 5, sir. Mr. Balavant, an old man by registered deed of gift, granted certain landed property to Rima. Mr. Balavant is there. Who was there, beta? Balavant. Balavant said, Amma Rima, I will give you land. But all these cases we have discussed in the face-to-face classes, sir. Or regular classes. Mr. Balavant, an old man, by registered a deed of gift to grant a certain land of property to Rima, his daughter. By the terms of the deed, it was stipulated that an annuity of 20,000 rupees should be paid every year to Mr. Savant, who was the brother of the Balavant. So, Balavant said to Rima, I will transfer the whole property to you. But one condition, you have to give 20,000 rupees per month to Balavant brother Savant every year. This is the condition. I'll transfer the whole property to you, but you have to give 20,000 rupees per month to Balavant brother Savant. So Rima said, okay daddy, I will give the 20,000 rupees to Chacha, that is the Chinnana, every year. So that's why Balavant transferred the property to Rima. So बाद में क्या हुआ था, Balavant will die. In the real life case also. On the same day, Miss Rima made a promise to Savant and executed in his favor an agreement to give the effect to the stipulation. So Rima said, okay, my dear Chacha, my dear uncle, every month, every year I will give you 20,000 rupees. This agreement was made between the Rima and Savant. So daddy transferred the property in the name of the Rima. Balavant transferred the property in the name of the Rima. Miss Rima fails to pay the stipulated sum. In an action against her by Mr. Savant, she contended that since Savant had not furnished any consideration, he has no right of action. Examine the provisions of the Indian contract, decide whether contention of Rima is valid or not. So Rima said, my dear Chacha, every month, every year, how much I am giving you? 20. What are you giving me in return? Nothing. So it is a nudum factor, no consideration, no contract. I don't want to give you anything to you. That is the argument of Rima. So Savant said, but Rima is Ushar, Savant, they Ushar. So Rima said, I will give you every month you are giving me. Savant said, every month you are giving me 20, every year you are giving me 20,000 rupees. I am not giving you anything, but something came from the your father. Consideration can move from the third party also. Same question, beta. Chennai versus Ramaya. So same question asked in the 2007 also. X transferred his house to his daughter M by way of the gift. If you observe here, same question, beta. In the place of Balavant, X came. In the place of Rima, M came. Okay, let me use the different color pen. That's why we should do the previous exam question paper, sir. Same questions will come. X M. M. The gift deed executed by X contained a condition that M shall pay sum of 5,000 rupees per month to N. In the place of Samantha, N came. N, the sister of the X, executed means X, sister of the X. Consequently, M executed an instrument in favor of N, agreeing to pay the said sum. Afterwards, M refused to pay the sum to N, saying that she is not liable to pay N because no consideration had moved from her. Decided with reasons under the provisions of the Indian contract that whether M is liable to pay the said amount to N. Answer is yes, she should pay, sir. Same question. Chinnaya versus Ramaya. So, seventh question, beta. Mr. Singh, an old man, but registered. Beta, if you do this question for the first time in the exam, can you able to answer, sir? Answer is no, sir. So that's why do this kind of questions before going to exam. The same question will come in the exam, sir. Copy paste question will come in the exam. Mr. Singh, an old man, but registered deed of gift, granted certain landed property to A, his daughter. Let me use a different color pen. Same beta. Singh agreeing to give the land to daughter A. By terms of the deed, it was stipulated that an annuity of rupees 2,000 should be paid every year to B. Seventh place B. B, who is the brother of Mr. Singh. On the same day, A made a promise with B and executed in his favor an agreement to give the effect to stipulation. A failed to pay the stipulated sum in an action against her by B. She contended that since B had not furnished any consideration, he has no right of action. Examine with the provisions of the Indian contract, decide whether contention of A is valid or not. What he is saying, but so A said to B, my dear Chacha, every month I am giving you money, but what are you giving me in return? Nothing. So I don't want to give you. Then B said, my dear beta, you are giving me 2,000 rupees. I am not giving anything. Something came from my brother Singh. Yes sir, no sir. Clear na? The answer. Provision of the law. Liko sir, if you're having my material, consideration need not move from party to contracts. Party to contracts. It can move from third party also. Which party beta? Third party also. In India, consideration may proceed from promisee or any other person who is not a party to contract. The definition of consideration as given in section 2D makes that proposition is clear. According to the definition, when at the desire of the promiser, promisee or any other person does something, such an act is a consideration. In other words, there can be a stranger to consideration but not stranger to contract. And I have explained the Chennai vs Ramaya case law and facts of the present case decision here. Thus, stranger to contract cannot enforce the contract, but stranger to consideration may enforce it. Hence, contention of the rema is perfectly not valid. She cannot say like that, she should pay. Next question, beta. Define consideration, essentials of a consideration. This kind of question will come for 7 marks, beta. 3 marks, 4 marks. This we have discussed, beta, this question. So this question came in the 2018 RTP and we have discussed previously also. 2018 के पहले 19. That means after 1 year gap, same question came. Yes or no, sir? 2019 also it came. Beta, this came in the November 18 RTP. The same question copy pasted in the 2019 exam, beta. Next question, beta. No consideration, no contract. No consideration, no contract. Just now we have discussed, I think, first question. First question also same thing, beta. First question and the question is exactly same. So you will know the importance of these questions. Hai na, beta? 1 second. No consideration, no contract. First question was asked in the year when beta? First question was asked in the 2018. Which month? May 2018. The same question came again in the 2019. No consideration, no contract generally, nudum pactum, no considerations, no contract. We have exceptions also. The first one is the agreement made on account of national event affection. Second one, promise to compensate past voluntary activity. Third one, promise to pay time bar debt. Next one, contract of agency. Last one is a completed gift, does not require any consideration. Next, 10th question by 19. What do you understand by consideration? Definition we should write. Are there any circumstances under which contract under the provisions of the Indian contract without consideration is valid? No consideration, no contract. Same question beta. First to 9th to 10th same. First to 9th to 10th. Hai. See how many times question is coming. Question number 11. Question number 11. Only a person who is a party to contract can sue and explain the statement and describe the exceptions. Describe the exceptions. If he is giving for the 5 marks, beta, if you explain the statement, he will give you 3 marks. If you write the exceptions, he will give you 2 marks. So what is the question, beta? Only person who is a party to contract can sue it. That means, can the stranger to contract sue? No. But stranger to consideration, sue. General rule. Which will, beta? General rule. Stranger to contracts cannot sue. Cannot sue. And we are having an exception. Stranger to consideration can sue. Stranger to consideration can sue. We have discussed so many exceptions also. We'll see one by one, beta. We have seen a famous case la Dunlop Tire Company versus Selfridge Company Limited. So here manufacturer will be there. If you observe, if you remember that case la, and wholesaler will be there, and retailer will be there, and customer will be there. There was the agreement between the wholesaler and retailer. As per the agreement, retailer should not sell the tire less than MRP. But retailer, if retailer sells the tire for less than MRP, no, he has to pay some damage to wholesaler. That was agreement between the wholesaler and retailer. But retailer sold the tires to customer for the less than MRP. Then manufacturer sued the customer. Manufacturer sued the retailer. Can he sue, beta? No, because manufacturer is a stranger. Manufacturer is a stranger. Stranger to contract cannot sue. We are having the exception, beta. That is a stranger to consideration. So following are the exceptions. First one is the trust. We have seen one case law also, beta. Indian government of India case law. And in case of family settlements, here also we have seen one case law. That is a Chinti is there, joint Hindu family is there, है ना, marriage, बेटी का शादी का डब्बा example we have seen, है ना. So exceptions. First one is the trust. Second one is family settlements. Third one is the marriage contracts. Next one is the assignment. Next one acknowledgement. Next one covenants running with land. Covenants means conditions, है ना बेटा. So in the following exceptional cases, even without even he is a stranger, still he can enforce the contract. Last one is the agency. Last one is the agency. In the following cases, even though he is a stranger, still he can enforce the particular contract. है ना बेटा. Next question, same repeated question, beta. So no consideration, no contract, exceptions. See how many times the question is being repeated. Nearly 5 times it is repeated, beta. Question was asked in November 2005. So an agreement made without consideration is void. With reference to provisions of the Indian Contract Act, examine the validity of the statement. Explain the cases in which statement does not applicable. First question, 9th question, 12th question, same question, beta. है ना. First, 9th, 10th, 12th, same question. No consideration, no contract, exceptions. And 13th also same. See, why means if you do like this, but you will come to know which is more important question. You will focus more on that kind of the question. First, 9th, 10th, 12th, 13th, same questions, beta. Next, 14th question, beta. May 2012, beta. What do you understand by term consideration? Definition. If you read the definition under section 2D, no beta, that is sufficient. Consideration under section 2D definition, you will get 2 to 3 marks, beta. Next question. X, an Indian, carries on a business in Pakistan. He entered into contract with Dubai who carries on the business in India. Immediately after formation of the contract, war broke out between the India and Pakistan. So, what is the validity of the contract between X and Y? This question is not related to this chapter. This question related to capacity of the parties, beta. है ना? Related to capacity of the parties. So, for example, beta, X is staying in India. X is staying in India and Y is staying in the Pakistan. So X entered into agreement with Y for sale of some goods for 1 year. After entering into contract, there was a war between India and Pakistan. There was a war between India and Pakistan. That means after entering into contract, Y become alien enemy. Alien enemy. So if the contract is as per public policy, as per public policy, during the war, contract suspended. After the war, contract revived. If the contract is opposite to public policy, opposite to public policy, the contract will altogether dissolved, comes to an end. This is step number 1 beta. So step number 2, X is entering into contract with Y for sale of the goods. Subsequently, war broke out between the parties. So that is step number 2. Step number 3, if the contract is as per public policy during the war, suspended after the war revived. If the contract is as per public policy, altogether dissolved. This is how you have to answer the 15th question beta. Next question. Same question beta. Chinnaya vs Ramaya. Nearly 6th time. An old lady made a gift of her property to her daughter with direction to pay certain sum of money to the maternal uncle by way of annuity. On the same day, the daughter executed in writing in favor of a brother agreeing to pay annuity. The daughter did not, however, pay the annuity to the uncle. Should to recover it, decide. So same question was asked. Which question beta? Question numbers previously. Question number 3 అనుకుంటా I think first. Question number 3, comma 3 questions will be there together. 3rd, 5th, 6th, 7th, and 16th. Question was asked 5 times in the exam beta. Same question, copy pasted question 5 times है ना. So focus more on the no consideration, no contact exceptions and this case la beta. Write it more number of the times. Write 3-4 times on your own without seeing the material. If you're having my material, close it, read it, close it, and write it. 17th question. A pays 5,000 rupees to B, and B promises to deliver him certain quantity of the wheat within a month. In this case, A pays the amount, whereas B has made only promise. State the nature of consideration. What is the nature of consideration, beta here? Already I gave the rice. Already SG gave the rice back to. I said to Rohit, Rohit, if you give me 1,000 rupees, I will give you rice bag. I will give you rice bag. है ना बेटा? So already I give the rice bag, but Rohit has to give the money. Money is pending. Money is pending. है ना? What is nature of the contract बेटा? Partly executed, and partly executory. Partly executory. है ना बेटा? This is the answer. Question is easy, but you have to get that answer in the exam hall. Blink होना exam hall में. Next 18th question beta. This from the ICA practice manual. I am putting MTPs, RTPs, previous question papers and ICA practice questions also together beta. So A is indebited to C 6 lakh, but debt is barred by limitation act. A sign a written promise to pay the 5,000 rupees in final settlement of the debt. Decide validity of the contract. Perfectly valid. Step number 1. So how to write this question beta? Step number 1. Because for everyone, those who are following the class, step number 1, provision of the law. No consideration is equal to no contracts. Exception. Promise to pay time barred debt. Promise to pay time barred debt does not require any consideration. Does not require any consideration. If it is in writing, if it is signed by the registration not required beta, if it is signed by the debtor, signed by the debtor. Step number 1. Step number 2, facts of the priority case. Step number 3, conclusion. So it is perfectly valid decision. So that loan is recoverable. Clear na beta? One more question beta. 19th question. To form the valid consideration, contract consideration must be adequate. It need not be adequate. It can be grossly inadequate also. I think second question is this thing only. Second question and 19th question. Same no beta? So but the moral of the story beta, these questions only will come in the exam. If you prepare these questions, no, that is more than sufficient beta. है ना? You will be coming with flying colors. है ना? Exactly questions will come in the exam, sir. So remaining part will see in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Chapter number 4 we will be seeing in the next class. है ना बेटा?